Good morning, everybody. I'm Jane Mann. I'd like to introduce our HRLaw webinar, one of a series. And today we'll be talking about whether or not you can dismiss an ill employee. It's an HR guide to managing serious ill health issues. And in this 1 hour, we hope to give you some useful pointers. So next slide, please. We'll have a look at the agenda for today. So I would first of all just like to introduce myself. I am Jane Mann. I'm a partner in the Employment and Immigration team here at Fox Williams. And I'd just like to mention a few administrative points before we get going with the main webinar. So there will be a recording of the webinar, and it will be made available to those who've registered before but are unable to join this morning. We're happy to take questions on the topics under discussion today, but could you please put those in the Q&A box rather than the chat box? We'll cover those or a few of those in the Q&A session at the end once the speakers have finished. The webinar itself will focus, as I said a moment ago, on the tricky issue of dismissing an employee fairly due to ill health absence. As we're all too aware, employers and very much HR professionals are often left walking on eggshells with a sense of nigh on paralysis in fear of getting it wrong, and it's resulting in serious legal proceedings being launched against the company. But help is at hand today. Today, we are going to try to debunk the myths around taking action, explaining fair and non-discriminatory ways to carry out an ill health dismissal of an employee. At the end of the webinar, my colleague Lucy Paxton will also give you a few top tips about managing ill health and ill health absence in the workplace more generally to try and finish the session on a positive note. I'm aware that we might sound a little bit heartless in sort of talking about just dismissing ill people, but we are trying to approach the topic sensitively and with due regard to obviously the very difficult situation that people find themselves in when they unfortunately become ill at work. Just starting off the session today will be Ed Livingston. He is a senior associate in our employment and immigration team, and he will start by outlining the employment law risks, addressing potential liabilities, and the fundamental legal concepts applicable to ill health dismissals. And that's the sort of building blocks for our session today. After that, we're going to hear from Grace Waterstone, who is one of our associates in the employment and immigration team, and she's going to be looking at the common pitfalls and how to avoid them. And then Lucy Paxton, another one of our associates in the employment and immigration team, will consolidate our recommended approach by setting out some top tips for dealing with difficult scenarios and giving you that guide to key things to do to manage ill health at work. So over to Ed now to get us started.
Thanks very much, Jane. Yes, so as we mentioned, the central question we'll be answering today is one that arises quite regularly for us. Can we dismiss an employee who's on long-term sick leave? The short answer in many cases will be yes. Employers aren't insurers against the risk of their employees falling ill and being unable to work. You can dismiss an employee who's in this position. But before you log off, unfortunately, the long answer in all cases will swiftly be followed by a but and an ensuing list of legal duties and potentially very expensive legal claims, which may be relevant and which, of course, make employers reluctant to grasp the nettle and move towards dismissal. So if we could have the next slide, we'll just look at some of these legal risks. I think I'll just rattle through them quite quickly to move on before we move on to Grace and Lucy for some discussion of the practicalities around what can be done to avoid triggering these potential claims. As you'd expect, every set of legal risks is impacted by the specific factual circumstances of the potential dismissal, but those are the sort of main legal heads of claims that we'll often be looking at. So next slide, please. If we focus in on disability discrimination as the first one. This is under the Equality Act and is the often the biggest legal risk that we're dealing with and needing to manage. It carries uncapped compensation and sort of will run through the whole process from start to finish. So I think it's a good place to start. We have the definition here up on the screen. It's a physical or mental impairment which has a substantial and long-term adverse effect on an employee's ability to carry out normal day-to-day activities. The impairment is long-term if it's lasted for at least 12 months, or it's likely to last at least 12 months, so it will catch conditions at their outset. There's no sort of accrual period, as it were. Um, Irrespective of whether you definitely have a disabled employee, it's advisable to obtain an up-to-date medical report from an occupational health advisor. In borderline cases where it's not clear if you've met the disability definition, the prudent approach without conclusive medical evidence either way is to be more cautious and treat the employee as disabled. A couple of examples of borderline cases that we see, long COVID, for example, my understanding is that it can encapsulate a number of different symptoms, but on the specific facts of one case in 2021, it was held to amount to a disability. Likewise, mental impairments. The mood disorders such as anxiety and depression could potentially have long-term adverse effects on employees. So, as with any other kind of protected characteristic, if you're dealing with a disabled employee, you must be careful to avoid allegations of direct or indirect discrimination or harassment relating to disability, as would be the case with any other protected characteristic. However, disability, we're dealing with two other key legal duties that you need to bear in mind. Firstly, you have a duty not to discriminate against an employee, i.e., treat them unfavorably because of something arising in consequence of their disability. For example, that will cover periods of sickness absence, unless that treatment is a proportionate means of achieving a legitimate aim, i.e., it's justified. And secondly, there is the duty to make reasonable adjustments where this would help the employee overcome a substantial disadvantage posed by their disability. So that's a very wide-ranging duty which could involve absolutely anything, but there are limits to it. There's guidance, and you'll have a steer from the occupational health assessment. Case laws also set out hard limits on it in terms of its scope. For example, it doesn't require you as an employer to create a brand new role for a disabled employee who's unable to carry out their current role. So that's disability discrimination in a nutshell, and that will often run through the whole process from start to finish, as I said. So if we move on to the next slide, please, Dan. Moving to unfair dismissal. So this is a separate statutory right, which may well be relevant. Quickly going back to basics, as many will know, an employee with 2 years service or more has the right not to be unfairly dismissed. You can dismiss fairly for one of five potentially fair reasons. We have three of them there on the screen, which may be relevant. Firstly is capability. You have the statutory definition there. Skill, aptitude, health, or any other physical or mental quality. Potentially, you might be dealing with scenarios where other potentially fair reasons for dismissal might be in play. Some other substantial reason, which is a sort of umbrella term, which we'll touch on later, and also misconduct that's not often in play, but it might be available if there's a failure to follow the employer's sickness reporting procedure. So that's the sort of gateways, the potentially fair reasons for dismissal. Now, if we quickly move on to procedure. Next slide, please, Dan. Once you've sort of correctly identified the potentially fair reason and addressed whether or not the employee is disabled, they often will be. You have to then sort of move on to how you can demonstrate how you establish a fair reason, a fair process for the dismissal, sorry. And what's reasonable is fact specific, dependent on the size of the organization and the employer's administrative resources. But in every case, it's crucial to follow a fair procedure. There's sort of three fundamental requirements of it are there. You have to establish the true medical position for the employee, take sensible steps according to the circumstances to consult with the employee, giving them the opportunity to state their case. And then thirdly, consider the availability of alternative employment. The process will need to be tailored, as I said, if the individual has a disability, since you have the duty to make reasonable adjustments. So moving on to the next slide, please. Unfair dismissal, just a really quick run through a sort of standard process as a framework, just on which Lucy and Grace can add a bit of detail, color, and practicalities. So first things first, using the medical information you've received, set out a written report, considering how the role could be adapted if that's possible, or what are the roles in the organization the individual could potentially carry out. Adaptations might be things like changing working hours, reducing workload, or requiring employees to avoid particular tasks. Secondly, consultation meeting. That's a meeting with the employee to talk about their medical condition, prognosis, any potential adjustments, any alternative opportunities, etc. To clarify, this is a consultation about the medical advice, the information provided, and the reasonable adjustments that might be made to the employee's role. It's not about the termination of employment at this stage. Thirdly, in the middle there, consider the information provided and document the exchange of views. That's all information, and this will probably look like an internal sort of cost-benefit analysis of the costs, business impact of keeping the individual, and anything else that the individual has to say about their ability to carry out the role. If after having conducted that analysis, it's looking like termination is the only feasible route, you would then have another meeting to discuss the termination. That is certainly something that has to happen before there is any sort of final decision reached. But the invitation letter for this meeting should certainly warn that dismissal is a possibility, but it should not sort of suggest that that is a fait accompli. You should also give the individual the right to be accompanied to the meeting, and then at the meeting itself, give him or her the opportunity to put his or her case forward and outline any mitigating circumstances. So after that, further consideration is required, and then if after the meeting the decision to dismiss is reached, you need to obviously advise the employee in writing of that particular outcome. And of course, as always, you should give them the ability to appeal the outcome and the time frame in which they need to submit their grounds of appeal. So that is the process in a nutshell, in order to avoid unfair dismissal claims or mitigate the risk of them. And then if I move on to the next slide, please, Dan, just to mop up the final set of potential legal claims we may be dealing with, depending on the circumstances. So thinking back to the original summary list of risks in my first slide, firstly, we've got personal injury. This is a claim under the common law. The employer, as you all know, has a duty to provide a safe place of work, reasonable care to prevent personal injury. That includes mental injury. The most common claim we'll see, dealing largely as we do with office workers, will be mental rather than physical injury. Stress and anxiety, when serious enough, can be deemed a psychiatric injury, but it is quite difficult for an employee to establish. They've got to establish that there was a breach of the duty, that the breach made a material contribution or otherwise caused the individual's ill health, and perhaps most importantly, it needs to be reasonably foreseeable, which is difficult for an employee to show unless the employer can be seen to have known of some particular problem or vulnerability that the employee had. Otherwise, an employer is typically entitled to assume that the employer is up to the normal pressures of the job. So that's personal injury. Then we've got pregnancy-related claims. Obviously, this will only apply to very specific circumstances, as you may expect, where an employee's sickness arises from pregnancy or maternity, there are special protections under the Equality Act and the maternity and parental leave regulations. Um, for example, you're not able to take into account um, illness or absences for the purposes of attendance management if these are pregnancy related. And lastly, but certainly not leastly, we've got breach of contract claims. For example, quite often employers will provide permanent health insurance to their employees, which gives them cover if they're eligible and unable to work due to illness for more than a minimum period. So in the Aspen case, as you can see there, there was an implied term. It was held that that prevented an employer from dismissing an employee without good cause, such as gross misconduct or genuine redundancy, where the effect would be to deprive this employee of their rights to earn under the permanent health insurance scheme. So breaching that term could be very costly for an employer because then it would be the employer that's on the hook for those payments for potentially a very long period of time. So something to look out for there. You may have an express right in the contract to sort of prevent the implied term from arising, but it's sort of not a tested point necessarily. So that's potentially not a silver bullet. And then finally, some other contractual rights to be aware of when dealing with absent employees. They may have rights to enhanced sick pay. In terms of, as with every dismissal, you'll need to give notice or payment in lieu, unless you're relying on conduct grounds. Likewise, payment in lieu of untaken holiday, which may well be significant if they've been off for a long time. And then finally, employers who have pension schemes that provide early ill health retirement benefits should ensure that the employees are considered for these before a decision to dismiss is taken. There was a recent EAT case that stated that employers are expected to take reasonable steps to ascertain whether the employee is entitled to any ill health retirement benefit. So that's another thing to tick off the checklist before going ahead. So that's a very brief tour of the central legal obligations that we're dealing with, just to provide a framework for the discussion. Now to move on to the slightly more interesting and practical steps that Grace is going to take us through. So over to Grace.
Thanks, Ed. Yeah, as Ed said, my name is Grace Waterhouse. I'm one of the associates in the employment team. And I'm going to be thinking about some of those common pitfalls that we see employers falling into, those big sort of sticking points on ill health related dismissals. And in particular, I'm going to be thinking about timing. So how long do you wait to enact a dismissal? Considering alternative roles, do you need to create a new role, for example? Short-term absences and how to deal with those ones that arise persistently. And then what happens when you think you might have been responsible for the ill health? And next slide, please, Dan. So starting with timing, how long do you have to wait? And as I know many of you listening will recognise, there comes a time when all you really want is finality and certainty. And that's particularly tricky where the employee hasn't been prompt or cooperative in providing up-to-date information about their medical condition. But not waiting long enough, or indeed waiting too long to dismiss, can lead to unfairness in the process. So the key question you can see on the slide there that you're going to need to determine in order to be clear on timing is, how severe is the impact of this employee's ongoing absence on you as an employer? When has it become too severe, and how can you evidence this? And ultimately, this is going to be a question that different employers will answer in different ways. For some employers, the impact of someone's absence will be felt much more severely, much more quickly than others. So it's a balancing exercise. From cases, we know that those factors on the slide there are going to be relevant in determining how long you're expected to wait. So, for example, the availability of temporary cover for the employee's role, including its cost. Can you even get temporary cover for it? Is it easy and fairly cheap? Is it more complicated? Sick pay and the exhaustion of sick pay. The administrative costs that might be incurred by keeping an employee on the books, and the size of the organisation. So what kind of evidence is appropriate is going to depend on the facts of the matter. Often it's going to be so obvious that the impact is very severe in terms of financial burden and no temporary cover. but sometimes it will be less evident. And you're going to need to give specific details as to the kinds of difficulties that the absence is causing. Try and keep accurate and detailed notes recording the impact of the absence and how you've made the decision and what rationale you've used. Then there's a question we often get about length of service. So does it make a difference? And the answer is yes and no. So a failure to give any weight to length of service may make the dismissal unfair. So for example, if you've got 17 years of unblemished service versus very minimal service, that's going to be a factor that should weigh in favour of the employee when you're considering the impact of their absence on you. But long service is not going to be relevant when you're determining the reasonableness of the investigation that you go through, that process that Ed talked you through. So in other words, an employer is not obliged to carry out a more detailed investigation in the case of a long-serving employee, but nor are you entitled to carry out only a casual investigation in the case of an employee whose length of service is short. And as I said, all of this is one big balancing exercise. And next slide, please, Dan. So now we're thinking a bit about alternative employment, because as we discussed earlier on in the webinar, we know an employer should consider whether there's any suitable alternative employment before taking the decision to dismiss. And in the same way as a redundancy scenario, alternative employment should be considered right up until the notice of dismissal has expired. And actually, in terms of past cases, we have seen in the tribunal employers falling at this hurdle. In fact, there was a case called Mackay, in which the dismissal of an employee who'd been off sick for 2 years was held to be unfair because of the employer's failure to consult with the employee about retraining in another role, despite the fact that the employer had consulted extensively in other respects. So what does this mean in practice? Well, the good news is you're not under a duty to create a job where none exists, but you might need to consider modifying some requirements of the job, both as a matter of reasonableness and for the purposes of unfair dismissal law. And as Ed mentioned in relation to discrimination law, that duty to make reasonable adjustments under disability discrimination legislation. So might the employee, for example, be able to do another role with a little additional training? For unfair dismissal purposes, the question of whether or not it's reasonable for you to waive or modify an aspect of the job will be a question of fact and degree. But some of the key principles to bear in mind: a dismissal is likely to be unfair where you're failing to even consider whether the requirement for an employee to carry out just a small aspect of the job could be reallocated. Some duties could just be minimal, can easily be done by another employee without sort of major inconvenience to you. So it's an important point to look out for, because if you've acted reasonably until now, but then you don't give adequate consideration to those potential alternatives, there could be a failure to act reasonably at the final hour. But the good news is that you'll be judged by whether you acted within the range of reasonable responses. So I think the big advice on this is consider the alternatives and be prepared to show the employee, and in a worst case scenario, the employment tribunal, that you did. Next slide, please, Dan. So one of the big things I wanted to cover was persistent short-term absences, because in fact, this is often more difficult to deal with than one stint of serious long-term absence. And often we see this arising in one of two ways. Firstly, sometimes it's persistent absence with the same linked condition. So you often see this with employees struggling with chronic conditions or mental health conditions that flare up. The second alternative is sort of regular periods of unlinked short-term bouts of ill health. So a cold, sports injury, COVID, a stomach bug, that kind of thing. And so the first thing to think about when you've got an employee taking persistent short-term periods of absence, is this actually a capability dismissal, or is it something else? What's in the forefront of your mind in making the decision to dismiss? A capability dismissal is only going to apply where, as Ed said, it's an employee's skill, aptitude, health, or physical mental quality that's leading to the dismissal. So this might be the case where those periods of absence are linked to one particular condition and it's causing significant disruption. But on the other hand, what you might have is, say, a failure to meet attendance targets, or a failure to comply with attendance procedure or sickness reporting procedures. And in that case, the decision to dismiss might better be characterised as an SOSR dismissal, that's some other substantial reason dismissal that Ed mentioned earlier, or even a misconduct type dismissal. Sometimes what we'll advise in short-term absence cases is that if taken to an employment tribunal, that you give the defensive capability in the first instance and then SOSR in the alternative. And that's because the task of identifying that real reason for dismiss ultimately rests with the tribunal. So if you've identified the reason wrongly, the tribunal can still substitute one of the other potentially fair reasons. Procedurally, recurrent absences are likely to look slightly different in the way that you deal with them, but the overriding principles of fairness are going to continue. And that means ensuring that the employee is aware of the standards of performance that you expect from them, the impact their absence is having on your business and their colleagues, and the likely consequences of formal action or dismissal in the event of continued absence. You should be adopting an approach of sympathy and understanding and compassion. Not only is this the right thing to do, but also it finds favour with a tribunal compared to appearing to act sort of callously or indifferently. And finally, I just wanted to emphasise the importance of thinking about ill health, where you've got recurrent absence but no immediately obvious underlying health condition. Now, often our clients don't want to bring the possibility of disability into the picture, where the absence seems random, where the employee hasn't raised ill health. But actually, tribunals will criticise an employer who just buries their head in the sand about this type of thing. If you think about conditions like spectrum disorders, long COVID, illnesses like ME, and particularly we're seeing this more and more in relation to symptoms of the menopause, often these present in a collection of different ailments and absences. So as an employer, it's worth getting to the bottom of these. You don't have to be a doctor, but just be careful not to unreasonably overlook or ignore those patterns of absence. Make sure you're giving the employee the opportunity to explain their absence, have a gentle conversation with them on their return to work, make the most of those return to work conversations to try and establish if anything bigger is going on. And where absence seems unusual, it's usually sensible for employers to establish the reason for absence via an OH report or a medical report, just to rule out or to deal with any potential disabilities or work-related causes or triggers. It's better to be forearmed with the knowledge. Next slide, please. So touching briefly now on situations where you might have caused the employee's ill health, thinking primarily about stress here, which is a classic example of this. The basic premise is that simply because ill health might be attributable to the conduct of you, the employer, that doesn't mean a dismissal will inevitably be unfair. But the key issue is whether the employer acted reasonably in the circumstances, which includes the fact that the employer was responsible for the ill health. So it will be a factor taken against you. But we have seen from a previous case called McCady that where an employee made it absolutely clear she wouldn't consider returning to work and medical evidence supported this, the reality was there was no alternative to dismissal. And what this case told us is that it can be reasonable to dismiss in these circumstances, but where an employer is responsible for the employee's ill health, it should normally make more effort to find alternative employment for the employee and put up with a longer period of sickness absence than would otherwise be reasonable. It's worth noting that if an employer is responsible for the ill health that leads to dismissal, it's entirely possible that an employee will have a claim against the employer covered under the employer's liability insurance, which of course can be extremely complicated. Next slide, please. Finally, I wanted to cover a few last traps to avoid. Firstly, avoid the enough is enough approach. And I say this with lots of experience of clients that come to us and say, we've just had enough. Very understandable. And there are things we can do. But the point here is, if you consistently take a very lax or tolerant attitude towards persistent short-term absences, it's not reasonable to suddenly turn around and take a final straw approach. So in a case called Connaughton, we saw an employee who had a generally poor attendance pattern over several years, which the employer had broadly tolerated. And then the employee had improved after 2 written warnings, but then had a period of 2 days absence and was dismissed. And the tribunal didn't think this was reasonable. because the employee had no reason to expect that dismissal was a likely consequence of just 2 days absence, given the employer's response before. And this goes to an overarching point. Try and manage these issues proactively and promptly. Consistency of approach is really key. It's going to be hard to fairly dismiss quickly if we haven't shown that the absence is problematic throughout. Number 2 of classic pitfalls is not following your handbook or keeping a proper paper trail. It's really surprising how often decisions are made without any regard to what your own policy says or without the documentary evidence to back it up. If you're finding that your policy is overly restrictive, it might just be worth taking a look at it to see how you can make it more manageable for you. And that's something that we can help with if you need it. And finally, number 3, if you're seeing lots of ill health in the workforce, particularly where you're seeing multiple examples of stress or anxiety, don't ignore it. More and more, we're moving away from a culture of employees simply accepting stressful working environments or unrealistic expectations. Do a risk assessment to see what might be going wrong. This will help with those types of allegations of personal injury or reasonable adjustments. That's everything from me, but do pop any questions in the Q&A box if anything I've said's raised a query for you. And I'm handing over to Lucy, who's just going to address some really sort of practical tips and scenarios.
Thanks very much, Grace. So I'm Lucy Paxton, one of the employment associates at Fox Williams. And we're now going to move on to thinking about what practical steps employers can take to guard against some of the liabilities that we've touched on so far. So next slide, please. So let's think about the early stages of an employee who's starting to repeatedly take time off work because they're unwell. Fortunately, some absence issues can be managed informally without the need to escalate matters. And depending on the circumstances, formal meetings and formal warnings may not always become necessary when a manager has a good working relationship with their team members and they can have a productive and supportive conversation about attendance. The ACAS guide on managing work-related stress gives some useful information for managers about how they can approach these conversations. However, when the absence level presents an unacceptable level of disruption to the business, an employer should deal with matters formally. And as Grace has mentioned, the formal steps should be followed in the relevant company policy. In a practical sense, how the matters handled in these early stages is really crucial. It's likely to determine if the employee will raise a grievance or will suffer additional stress that they may later allege was caused by the employer. So it is really important to get this right. The employer should press ahead with the relevant formal steps when required, rather than shying away from the process. Some sickness absence policies provide for a trigger point, after which the absence or series of absences will be dealt with formally in accordance with the procedure set out in the policy. But even when an employer doesn't have such a policy in place, it should set out to establish the following. First, the reason for the absence, and booking an occupational health appointment to establish the employee's health condition and consulting with the employee can assist with this. Next, in cases of long-term absence, when the employee is likely to return to work. And in cases of short-term intermittent absences, when the employee is likely to show improved attendance patterns. Next slide, please. So let's look at the first meetings in managing sickness absence cases. In long-term absence cases, the first meeting should explore, firstly, the likely date of return and whether the employee can continue to wait for the employee to return. Secondly, arrangements for future contact during sickness absence, further medical review, and further meetings under the procedure. Thirdly, whether the employee has a disability with reference to the occupational health report. If they do have a disability, the employer should consider what adjustments could enable the employee to return to their job and whether those adjustments can actually be accommodated by the business. Now, if the employee is disabled, the employer has a positive duty to make any adjustments that are reasonable. Fourthly, you should explore what alternatives the employee may wish to consider, such as redeployment into an alternative role or an application for employment benefits. And fifthly, you should consider a return to work programme with the employee. Now, in short-term absence cases, it's important for the employer to address whether there is an underlying health condition causing the absences and to satisfy itself that the absences are genuine. So in a first formal meeting to discuss short-term absence, the employer should explore first if there are any other factors that the employee wants to share with the employer about their absence. The employee's absence may not even be health-related. It could relate to a problem with a colleague or their manager or workload. So it's good to try and bottom that out early on. Secondly, the effect of the pattern of absence on the employee's colleagues, their department, and the employer's business. Thirdly, the likelihood of the absences continuing and the impact they are likely to have if they do continue. Fourthly, whether there are changes to the employee's job or redeployment opportunities that would assist attendance and reduce the effect of that attendance on colleagues and the employer's business. And lastly, again, whether the employee has a disability, and if so, whether there are any reasonable adjustments that could be made to improve their attendance and enable them to perform their role. Now, the employer will want to consider if giving a warning is appropriate where short-term intermittent absences have taken place and there's no underlying health condition. Any warning should only be issued following a fair procedure and should be accompanied by timescale and suggestions for improvement, together with details of the action that the employer will take if there's no improvement within the specified timescale. What action is appropriate is always going to depend on the specific circumstances. So, for example, employers should examine the reason for the absence during the period given for improvement, the likelihood of further absence, and the impact of the absence on the employee's department and colleagues. The employer's actions should also always be consistent with how they treated other staff in similar positions. So an employer should hold effective discussions with the employee to ensure that genuine consultation takes place. As Grace mentioned, all conversations should be noted in writing so that the employer has that paper trail. And it goes without saying, but showing empathy and trust rather than merely paying lip service to the policy is really beneficial. It will often bring to light facts and circumstances that the employer wasn't previously aware of, and it can throw new light on the reality of the matter, which can help it to be addressed more effectively. Sometimes the employee may wish to obtain their own medical evidence, and this might be appropriate where an employee suffers from a condition that would benefit from their long-standing medical advisor or consultant providing their opinion on the matter, as opposed to solely relying on the occupational health report and advice. Now, while an employer should have regard to the employee's views about their own health and prognosis, the relevance of what an employee says about their own health as opposed to a medical specialist may vary. So particularly where an employee's health problem is of a psychiatric or psychological nature, their views may not be wholly reliable, and especially if it appears to be contradicted by the medical evidence. In those circumstances, the employer will look to say that it's reasonable to rely on the professional medical opinion that they have obtained. Next slide, please. So I'm just going to touch briefly on the data protection considerations when managing sickness absence cases. As you'll be aware, employee health data is a special category of personal data. An employer must comply with the relevant GDPR provisions when storing and processing such data in line with its staff data protection policy. So if the employer hasn't done so already in a sickness absence case, provide the employee with the staff data protection policy and ask them to acknowledge that it's been read. As you'll also be aware, an employer needs to keep confidential, secure records of medical certificates, correspondence, and notes of calls and meetings that take place during sickness absence processes. Now, a special process must be followed when an employer is obtaining a medical report from an employee's GP. So in contacting the GP for a medical report, you need to use the correct employee written consent form. And it should note that the employee's consent in accordance with the Access to Medical Records Act 1988 has been obtained, and that the employee has been informed of their rights under that legislation. It should confirm if the employee wishes to see the report before it's released by the GP to the employer, and note the period of 21 days in which the employee can change their mind about that. If the employee does wish to see the report, they have 21 days from the date of the employer's application for the report to make arrangements to see it. And lastly, you should ask if any fees will be incurred in preparation of the report and the likely timescale for when the report will be released. And finally, of course, the employer should also obtain relevant consent from an employee to contact an occupational health advisor and to arrange an appointment for that, and to release the occupational health report as well. Next slide, please. So you may recall that earlier on in the webinar, Ed talked about personal injury claims, and he detailed potential psychological injury claims. Now, practical steps to reduce these claims are as follows. Firstly, monitoring the workload and capacity of staff members. The correlation between overworked staff and psychological injury is really significant. And as such, taking steps to ensure there's a paper trail to demonstrate effective planning and work distribution has taken place is really beneficial. Secondly, regular consultation with staff members. So ensuring ongoing discussions, one-to-one meetings with managers, and consultations with employees will help employers to identify when stress levels among employees are rising and whether there's any risk of them suffering psychological injury as a result. Again, keep a record of any of those conversations and the steps that have been taken to address any concerns that have been raised. Now, employers can provide employees with access to facilities such as mental health hotlines and any employee assistance programs. And it may also be worth considering whether to provide employees access to medical insurance. Facilitating access to treatment for both physical and mental injury will help to reduce the severity of an employee's injuries and help to prevent long-term harm being suffered. Next slide, please. So now we're going to look at how employers can encourage rehabilitation into the workplace as opposed to dismissal. Choosing to make appropriate adjustments to allow employees to return to work where possible rather than dismissing has the benefit of demonstrating that the employer has behaved reasonably in relation to any subsequent dismissal if it does indeed become necessary later on. So the guidance from the Health and Safety Executive recommends that employers agree a suitable return to work plan with input and agreement from the employee before they return to work. And this would incorporate advice from relevant medical professionals and occupational health. Guidance also recommends that employers continue to make adjustments to help ensure that the return to work is feasible in the long term. I'm just going to run through some examples of adjustments that may facilitate a return to work depending on the circumstances. So the first is a phased return to work. So this can involve an employee coming back on reduced hours, and they could then begin to increase their working hours gradually back up to their usual rate. Varied start and finish times. This might be assist an employee with an illness or disability who might otherwise find it difficult to travel at certain times or require specific periods of rest. Alteration of or reallocation of duties. So an employee's duties could be reallocated to colleagues either in the short term or long term where required. But it's important to remember that any significant change in duties shouldn't be done unilaterally, and it should be agreed in advance with all members of staff involved. Now, employee could return to work in an adjusted capacity. So in a case of long-term absence where the employer has engaged a temporary replacement or support, it might be appropriate to keep that temporary help in place for the time being to enable the employee to refamiliarize themselves with their duties. And this might be particularly helpful if there's need to maintain a particular level of service and there's some doubt as to whether the employee who's returning to work will be able to meet that demand straight away. Now, reallocation of employees' workstations. So this could remove obstacles to efficient working, for example, by avoiding a staircase for an employee who has mobility issues, or moving away from a noisy office, an employee who has hearing difficulties. And finally, purchasing equipment or software. So that can assist an employee to carry out their duties as well. We generally advise to agree with the affected employee that any adjustments will operate for an initial trial period, following which the parties should meet to review their effectiveness and discuss any changes that might need to be made. I'm just going to touch briefly on the rate of pay for an employee during a phased return to work. So unless it's specifically addressed in the contract, how much pay an employee should receive while they're performing less than their full contractual hours is a matter of agreement for the parties. And it's common for the employer-employee to agree a pro rata rate of pay for the actual work that the employee is doing. It's unlikely that in the absence of an express agreement, the employer would have a contractual duty to pay full pay for partial performance of the contract by the employee. And it also seems unlikely that this would be required as a reasonable adjustment in disability cases. Where the employer has an enhanced occupational sick pay scheme, entitlement to full pay during a phased rehabilitation period may depend on the wording of the scheme. But employers should exercise good sense over this, because where an employee is potentially still entitled to full pay or half pay for remaining at home on sick leave, it may make little sense for them to be paid less money for actually coming into work and performing some work. So that's something to consider. Next slide, please. So to finish off, we're just going to run through our top tips for preventing and managing ill health. Now, so communication is absolutely key, and it's really important to strike the right balance when managing sickness absence, not to scare employees into attending the workplace when they may be too unwell to work, or they may actually be infectious, which poses a risk to other employees. But at the same time, encouraging attendance and preventing non-genuine sickness absence cases. Health and safety risk assessments shouldn't just be a tick box exercise. These should really be viewed by the employer as tools that are useful to aid the business and to assess and control the risks. We'd recommend workshops and training sessions for managers on absence management in accordance with the company policy. We find that issues often arise because of misunderstandings between the employee and the business. And it's really important that absences are handled with sensitivity by managers and never presumed to be disingenuous unless the employer has a good reason. Perceived stress in the workplace also shouldn't be ignored, and employers and managers should be looking out for early warning signs and have the appropriate support tools in place. Regarding policies, check that the existing absent management policies and procedures are effective, up to date, and provide clarity. Keeping the policies and procedures current by periodically communicating with the workforce in an open, transparent manner, and inform them of any changes to the policy. It's useful to consider including wording such as a trigger point after which the absence or series of absences will be dealt with formally in accordance with the procedure. It's recommended to review the absence management systems in place to ensure they're meeting the needs of the business, including the occupational health service that the employer uses. And monitoring absence levels should be a key part of any system, as the business will need to know what kind of absences it's dealing with in order to manage these effectively. Employers should consider health and wellbeing initiatives and schemes which can be made available to employees. So this might include teaming up with external support partners, such as mental health professionals and counsellors, and providing medical screening, exercise and mindfulness education. The evidence, as I'm sure you're aware, has shown that a happier and healthier workforce reduces issues relating to sickness absence and increases employee morale. Now, regarding pay and benefits, if the budget permits, employers should consider whether it's time to offer enhanced benefits such as sick pay, medical expenses insurance, and permanent health insurance. It's of course important to strike a right balance when considering these benefits because often sick pay schemes which are too generous are more at risk of being misused. But they may also be badly needed in the current climate to support unwell employees. Sick days can be used by employees who are exhausted from the job and require a break. And it's equally really important to ensure that staff are using their holiday entitlement to make sure that they are getting that break from work. Employers should look out for patterns in data, such as higher absenteeism in certain teams, seasonal trends, and a spike in certain types of absences. So look out for signs that particular employees or teams may need additional support or changes. Perhaps an employee has personal issues or caring responsibilities and would instead benefit from a flexible working pattern or reduced hours. Higher absences in particular teams could show that they're under too much pressure or being overworked and that changes need to be made in that team. Now, regarding budgets, it's a good idea to review the assumptions on which financial budgets are being prepared, both in relation to revenue and costs, to ensure that accurate assumptions are being made in assessing likely attendance levels at work, productivity, and the cost of programs that are designed to prevent ill health and to provide support to unwell members of staff. And finally, as with any strategic plan, ensure that actions are delegated to the appropriate people within the business, objectives are set, and outcomes are measured and reflected upon. Our top tip would be to focus on communication and delivery of information to employees. Don't just rely on the staff handbook to do the talking. Okay, that's all of our top tips. So I'll now hand back over to Jane.
So thank you all very much. And just a mention of, from the next slide, please, how we can help. And we've got a lot of experience of dealing with these issues, which is why we suggested doing a webinar on this topic today. And I hope you found it useful. So we can help with the management of particular employee relations situations, dismissals, managing managing litigation, and we can, of course, draft the suite of documents that Lucy's just been referring to, policies and procedures. So do get in touch if you think we can be of any assistance to your issues in this area. We've been having a steady stream of interesting questions coming in during the webinar. We've got about 6 or 7 minutes left at the end. So I'm just going to ask the panel. There you are. There's our contact details if you want to get in touch. Dan's just put them up. But giving a little bit of immediate assistance to everybody right now. There's one or two of you have been asking about how long that you have to wait before you can take action in relation to someone who's on long-term ill health. So for the purpose of answering this question, can I sort of ask the panel to assume that there's no permanent health insurance scheme or ill health retirement plan, but just in the unfortunate event that someone's just been off work for, say, a year or two, are there any sort of guidelines on that? I don't know whether Ed or Grace might want to dive in on that one. And then Lucy, I'll come back to you on something else that someone has asked.
Yeah, I can take it. So assuming there's no PHI, I think the big question you want to get some reassurance on is whether or not there's actually a prospect of return to work. And an OH report will help with that, even if the answer is we don't know when the employee is going to be able to return to work. But a question that's answered like that, or a question that says there's no prospect of them returning to work in the next 6 or 12 months, for example, can be a good trigger point if you've not got a trigger point in your policies. I think also just making sure that you've properly consulted with them so that they're sort of aware that this is potentially coming, that can also be quite helpful, having those discussions with them early on. Ultimately, there's not going to be a time when we say, yes, you tripped over onto now it's fine to dismiss. Think about the impact it's having on your business, and think about the prospects of returning to work. And those two together may well suggest that you can start the process. The other thing to say is, of course, the process does take a little bit of time. So it might be that you start the process and actually in having that discussion with the employee, it transpires they can return to work in a slightly modified way. So starting the process itself doesn't necessarily lead to a claim. It may be that they can return to work.
Yeah, a question of judgment. So I'm going to just move on to another question, which Lucy's going to deal with. If you suspect someone is disabled, can you treat them in that way, even if they have not told you that they are disabled? What about that when you suspect someone's got a disability, Lucy?
Yeah, that's a really good question. So I would recommend trying to get more information about the employee's health condition, to understand whether it's likely to be a disability, by referring them to occupational health and consulting with the employee, and trying to, obtain as much information you can about how long the condition's been going on, and how it's impacting them on a day-to-day basis. You can ask occupational health for their opinion as to whether the employee's condition is likely to constitute a disability. Occupational health view on this is not conclusive, but it should give the employer a good steer on that question. But I would say if an employer suspects that an employee does have a disability, the prudent approach would be to treat them as such by considering what adjustments may be needed to support them in returning to work or performing their role. And the reason for that is that for an employer to have a legal duty to a disabled employee, they don't need actual knowledge of a disability. They can be deemed to have that knowledge if the employer ought reasonably be aware that the employee was disabled based on the facts that they are aware of. So yeah, I think ultimately, initially, the best approach is to try to get more information to get to the bottom of whether the employee is likely to have a disability. But it's better to err on the side of caution, I would say.
Um, and another interesting question has been raised around pay and pay during a phased return. Ed, maybe one for you and me just to think about. If a contract is silent on pay during a phased return, can the employer decide to adjust the pay to match worked hours? And you mentioned, Ed, in your bit about what's a reasonable adjustment, and does a reasonable adjustment have to include paying an employee who's not able to work? And I don't know whether you have any thoughts on that point.
Yeah, I think generally you can use sort of prorating as the starting point if you've got a phase return where they're sort of on half hours, 2.5 days a week. I think you can. There are cases that go either way in terms of whether it would be a reasonable adjustment to be more generous than that or not. The sort of the old school thinking is no, but there's certainly caveats to that. I think, for example, if there was some suspicion that the employer was sort of caused or contributed to the injury, then you want to be more generous, for example. And also, as the point Lucy made earlier, if you've got a sort of period where you're entitled to kind of full sick pay for sort of up to 3 months absence and maybe sort of half for the next kind of three or something like that, a fairly generous enhanced sick pay regime, it doesn't make sense to pay someone half their salary to return to work on a sort of 50% basis when you'd be paying them full salary to not be at work at all. So you need to kind of make sure that is covered off if the contract isn't it has enhanced sick pay. But yes, typically they would be silent on pay as regards a phased return, and you can use prorating as a starting point.
So time for one final question. There are a couple of questions about what happens if you can't get hold of the occupational health report because the employee doesn't want to release it, or the employee is abroad and says, well, I'm abroad, the doctors here don't answer questions from UK employers. So the employer is in a position where there's foot dragging for whatever reason on the part of the employee regarding the production of sort of medical evidence, what's the employer to do then? Just a quick fire answers from do you just have to take it at, base the decision on what you know, having gone to, as many reasonable lengths as you can to get fully informed? Any thoughts from anybody?
Yeah, I think that's right, Jane. I think it would be worthwhile if the employee is refusing to release the occupational health report. I think it would be worthwhile employer having a conversation with them to explain that the benefits of the employer understanding their health condition, the impact it will have on their job, and what support the employer can put in place for the employee. And so there's a real benefit in the employee having that report. But ultimately, if they won't release it, then I think that there are other steps the employee can take to try to get information about their health, such as asking the employee whether they'd be more comfortable with getting a report from their own GP. But ultimately, if you can't get that medical evidence, then the employer does just have to proceed based on the information that they do have access to, which is a difficult situation to be in. But if you kind of exhausted all of the options in trying to get medical opinion, then that's the last resort.
Oh, well, thanks, Lucy, and thanks to all of you very much for excellent presentations. Our time is up. We've reached the end of the session. I'd like to thank all of you who tuned in and listened very much for doing so. I hope you found it useful. Final question was, will we send the slides out? Answer, yes. And so we'll say goodbye for now, and thanks for listening.